It's about criminal liability for physicians. What degree of misconduct would expose a physician to criminal prosecution as opposed to discipline by their professional body? We have a job here to look after the vulnerable, and there will be some problems, no doubt, where a physician assisting crosses the line. We've been urged to put a lot of our eggs in the basket of the disciplinary powers of a college, but there still is criminal liability in certain circumstances. So I'd love you to talk a little bit about that boundary.
Yes, and as I mentioned before, it's a heavy hammer, the criminal law, and one might question whether or not it ought to be used at all. I mean, the question of counseling suicide is really a subset of homicide law. In many cases, if not most cases, counseling suicide is just another category of murder without the mandatory minimum sentence of life imprisonment. So using the criminal code to criminalize the conduct of physicians who might fall afoul or run afoul of the exception that's to be created and seen in essence in Carter might be seen as a fairly heavy-handed way of dealing with those physicians. So the question you pose is a very good one, and the answer might lie more in the use of Crown discretion, because Crown attorneys exercise discretion every day. In fact, in even laying a counseling suicide charge, as opposed to a murder charge, there's an exercise of discretion there, which creates a massive difference.
Well, just to build on that, then, presumably the charge in the worst case of misconduct would be either unlawfully assisting a suicide or homicide.
Murder, yes.
Yeah. So one carries a maximum sentence of 14 years, I believe, and the other a life sentence. So if that's true, wouldn't that create an incentive for physicians to prefer assisted suicide over voluntary euthanasia?
I'm not sure I understand how that...
How do there's two sections that we have to deal with of the criminal code here in the circumstances. One could be a charge of homicide, and one could be a charge of assisting suicide in an appropriate way.
The premise of your question, I think, might be based on answers given by, and I apologize, I don't remember her name, but she's a counsel at the Department of Justice who seemed to equate counseling suicide with physician-assisted death, whereas euthanasia would be more tantamount to murder. And I don't agree with that characterization. Physician-assisted suicide, if it runs afoul of the exception in Carter, is in every conceivable way that I can think of, murder.
Right.
It's a matter of Crown discretion that a person is not charged with murder, but rather with counseling suicide. So aiding and abetting a murder, for example, to take it out of the physician-assisted suicide context, a person who provides the getaway car to someone who will then go on to commit a murder, if that person provides the getaway car to that person knowing that they're specifically intending to kill someone, is equally guilty of murder.
Right.
So,
Thank you, Mr. Romano. I'm willing to give Mr. Rankin one more minute if Ms. Hickey wanted to comment, because you were implicated in there on that boundary between criminal and regulatory discipline. I don't know whether you had anything you wanted to add.
I would just reinforce what Mr. Russomanno said in terms of the bluntness of the instrument of the criminal code, and urge that professional standards be developed on the more nuanced areas involving the clinical judgment of physicians that can address individual circumstances, so that the provisions of the criminal code deal only with those provisions that require clarity on the eligibility criteria that will then give physicians the appropriate discretion to exercise their judgment, which would then fall within the realm of the medical regulatory authorities provincially to address it in the type of nuanced way that can better be accomplished through that mechanism than through the blunt instrument.
Just before we move to Senator Doyle, I wanted to give Mr. Russomanno a chance to clarify something for the record. Our analysts are questioning, and it does refer to Section 241 of the Criminal Code, which has an A and a B. A refers to counseling a person to commit suicide. B is aiding and abetting a person to commit suicide. And Carter is dealing with A, and you kept referring to B, but we're blending them. We just want to make sure we can clarify this so we could use it for testimony.
Thank you. I appreciate that opportunity. We're talking about different kinds of party liability. So under Section, I believe it's 21 of the...
was B and A I mixed up, but you get my
Okay,
point.
I'll take your word for it either way. Party liability generally is dealt with under Section 21 of the Criminal Code for most offenses, for example, for aiding, abetting, or encouraging an offense. So there's different kinds of party liability. You can actively, just through words, encourage someone to commit a criminal offense, which seems to be parallel to the B, the 241B, whereas the actual act of aiding, which is perhaps providing the life-ending medication to someone, goes beyond mere words of encouragement and actually playing a different role in bringing about the end of that person's life. But either way, you get to that end result, which is liability under the criminal code. So those are just different expressions of party liability through different means.
So should we not consider that there is a middle ground and propose in our report to Parliament that in case of breach of the law that we would be drafting, that there should be some elements to consider in terms of penalty, either as the mitigating factors or a different scale of penalty?
Well, it sounds like an issue of sentencing, if I understand correctly, and as it stands, 241 provides a maximum sentence of 14 years. It would seem that there's a wide latitude in terms of the sentence available. One thing I should say to clarify as well with respect to using the criminal law to render physicians liable is that we have the added protection in criminal law of mens rea, of the mental element of the criminal offense, that not only would so a standard of negligence, for example, would not be high enough presumably to meet the mens rea, which is more often than not in the criminal code a subjective component. So there would have to be a specific knowledge on the part of the physician, presumably, that the person is not consenting in a competent way. So that may address some of the concerns with, physicians being liable for acts that may run afoul of the Carter exception. In terms of a penalty, yes, I mean, I think that just generally speaking, the Criminal Lawyers Association thinks that the criminal code should be used sparingly, and that very often there might be other regimes in place to deal adequately with these kinds of misconduct, if I can call it that way. I'm not trying to take away from the seriousness of the situation, of course, but there are regulatory bodies that do handle physicians that are negligent or do have acts of misconduct in this regard. So I'm not sure how else you might build in discretion in sentencing in the criminal code. With the maximum as it exists, it would seem that there already is in place quite a significant latitude. I believe it is a straight indictable offense, so perhaps there would be additional latitude by making it a hybrid offense. That would give additional discretion on the part of the Crown Attorney.
That's what I was contemplating. That was to be my next question.
Yeah, so
because that would be a way for the Crown to exercise discretion on the nature of the circumstances in which the breach happened and give an opportunity to mitigate, as you said, the strength of the criminal code as it is now in relation to that offense.
Yes, and generally speaking, the summary conviction offenses carry a maximum penalty of only 6 months imprisonment, in some other cases 18 months, but as a maximum. So that's one of the major differences. It also just generally represents a less serious offense when the Crown elects to proceed by way of summary conviction. So that might be a way to include greater latitude in the criminal code, certainly.
And since you are a lawyer also, Dr. Bach, Grant, could you, and of course Madam Hickey could certainly have an idea on this. What's your view on that?
There are two types of potential breaches. Perhaps that's overly broad, but the two potential breaches I foresee are the inappropriate provision of PAD, and if that's accompanied by a mens rea, that is inherently criminal. If it's not, then it's the inappropriate exercise of professional judgment, and that's regulatory. The regulatory colleges are familiar with these overlapping spheres. Sadly, we face those cases all too often. The other type of breach would be the inappropriate blockage of access. And as I made the point in my submissions, I worry about that. And if a physician, through obfuscation or what have you, inappropriately blocks access to an otherwise eligible patient, I know of nothing that would call that criminal as yet. That would be before your committee to consider. But I would say that would be something that a regulatory body would deal with quite severely.
Back on the definition of an hybrid offense. The criminal code contains a certain number of hybrid offense. Could you explain to us, to the members of the committee, the principles that preside over an hybrid offense versus an indictable offense? In other words, what are the substantial elements that defines an hybrid offense in comparison with an indictable offense?
Okay, I can do that. So for an indictable offense, there is no time limitation as to when the alleged offense occurred. It could have been historically years earlier, whereas a summary conviction or a hybrid offense, which allows for the possibility of a summary election, would have to be 6 months since the date of the alleged offense. So I should back up and say that for a hybrid offense, what that means is the Crown has the power to decide whether to prosecute by way of summary conviction or by indictment. A straight indictable offense is just simply that. It's indictable. So the other limitation on a summary conviction offense is that the maximum sentence is 18 months, and that's only for a prescribed few offenses. Procedurally, there's other limitations with summary conviction offenses in that they are they're tried in the provincial court. In Ontario, it would be the Ontario Court of Justice, and there's no right to elect a judge and jury trial. For indictable offenses, with some exceptions, there is a right to elect mode of trial with a preliminary inquiry or a trial by judge and jury. Of course, there's exceptions in the law, but those are the broad differences between a hybrid, which allows a choice, and a straight indictable offense.
So you don't see any circumstances into which, in relation to physician-assisted death, that there would be circumstances for which a different offense can be created than the one that the codes provide now in relation to 241.
A different offense that does not have the same elements. I don't see what a different offense would look like. And I would say that given the legislative objective of protecting the vulnerable from being in a state of weakness, as the Supreme Court puts it in Carter, to be coerced to commit suicide, that's a very serious offense. With the commensurate mens rea, that's a very serious offense, of course, because a physician in that context would be bringing about that person's death without their consent. Again, I go back to my earlier comment that this is not really different from the offense of murder. It carries the same elements: the causation, substantial contributing cause of death, and the specific intent to bring about that person's death. And so I'm not sure if there would be room for another criminal offense, and I'm not sure that the CLA would really be in favor of creating more criminal offenses to criminalize the conduct of individuals in this context.
In relation to the role of the College of Physicians of Nova Scotia, when you conduct inquiry in relation to negligence, to professional negligence, what makes the distinction between professional negligence, that in some cases might be very important in terms of consequences for the bodily integrity of the person, and a criminal code offense?
Sure. So, with respect to the discussion you were having with Mr. Russomanno, I would worry that the contemplation of a hybrid type offense, a watered down criminal charge, would have the effect of chilling physicians from providing this service, that it might act as a deterrent to consider getting into this realm of practice. The colleges often deal with complaints and conduct investigations that may overlap with the criminal sphere. There are some times when there are positively articulated obligations of the college. If, for instance, we see anything that involves sexual abuse of a minor, we immediately, per force of statute, involve law enforcement. So we would need clear direction about the criminal code provisions, and we would adhere to them. I think that there's most of the colleges, or I can't speak for most of the colleges. I can tell you that in Nova Scotia, we have an effective, close working relationship with law enforcement. If there's a matter that seems on its face potentially criminal, if we have reasonable grounds to suspect there's criminal activity, we make a determination based on the immediate public safety, which may involve suspending a doctor's license on an interim basis, informing the Crown, and then waiting for the Crown to conduct a criminal investigation. The parts work fairly smoothly.
So you have the experience of that kind of cooperation.
Sadly, sir, yes.